Please be seated. Proceedings are resumed. Madam Clerk.
The Development and Planning Amendment Bill 2016.
Recognize the Honorable Minister responsible for planning.
Madam Speaker, I am moving the second reading. I move the second reading of a bill for a law to amend the Development and Planning Law 2015 revision to make further provision in respect of the enforcement of planning control and to make provision for incidental and connected matters.
The bill has been duly moved. Does the Honorable Minister of Planning wish to speak to the bill?
Thank you, Madam Speaker. Madam Speaker, the amendments that I am putting forward to the 2015 revision of the Development and Planning Law are all fairly straightforward and simple, with crossed fingers, I say, and I would just like to run through those amendments in short order. Madam Speaker, while these amendments are not many amendments, I believe they are of significant importance. They also reflect important changes as a result of consultation with stakeholders and industry circumstances. For example, Madam Speaker, of particular importance was a recent ruling of the Grand Court on the 8th of April, which highlighted a discrepancy between the law and regulations with regards to the setbacks of multi-story buildings. So we have, for the avoidance of doubt, fixed this regulation, which, when I bring the government motion on the amendments to the regulation, we will see those changes. First of all, though, let me simply, at this point, deal with the amendments to the law. Clause 2, Madam Speaker, seeks to amend Section 13 of the Principal Law with a view to ensuring that all walls along roadside property boundaries, regardless of height, require planning permission. In this way, setback or truncation requirements may be imposed if necessary in order to ensure the safety of pedestrians. So, going to Section 13 of the law itself, Madam Speaker, Section 13, subsection E, as it reads now, let me start off at the beginning of Section 13 so we'll understand what E relates to. In this law, development means the carrying out of building, engineering, or other operations in, on, over, or under any land, the making of any material change in the use of any building or other land, or the subdivision of any land except that the following types of developments shall not require planning permission, but shall be subject to all other provisions of the law and any regulations made under the law, including the building code regulations, namely. So let's go to E now. E reads, the erection or construction of gates, fences, walls, or other means of enclosure not being with any setback adjacent to the sea, not exceeding 4 feet in height, and not constructed of sheet metal. First of all, Madam Speaker, when we read E, I do believe, and this has been pointed out to me by the elected member for Northside, and on the surface I agree with him. I think where it says with any setback should actually read within any setback. Doesn't say so in the amendment, but I believe the Honorable Attorney General can deal with that because it's a simple, or do we have to bring committee stage amendments? I think the Attorney General can deal with that. No. Okay, fair enough. Okay, we'll deal with it by ad-libbing in committee stage. So, and that, as I said, is just an observation that was pointed out to us, which I happen to agree with. So what it will read now is, within any setback adjacent to the sea. That's what it says now, and then we have to add to that, or road, so that where what obtains presently is if there's a fence being put down that is 4 feet or less on the road, there is no planning permission requirement. This is not about creating more bureaucracy, Madam Speaker, but I'm sure many of us have faced situations where people erect fences on their boundary lines and they create traffic hazards, danger to life. So the reason for this amendment is so that if there's anything going on the boundary, on the road, they can make an application to the planning department so that the planning department can view from a technical standpoint whether there needs to be any amendments to what the individual or entity proposed to construct to ensure that there is no traffic hazard or anything being created by what is being constructed. That's the simple amendment that is being proposed to this section. The next proposed amendment, Madam Speaker, is Clause 3 of the bill, which is seeking to amend Section 18 of the law to extend from 3 years to 5 years the period during which the Director of Planning may issue an enforcement notice in respect of development that has been carried out without the necessary grant of planning permission or without compliance with a condition of planning permission. This extended period would enable the proper investigation and processing of enforcement notices. And I may as well deal with Clause 4 at the same time because, Madam Speaker, Clause 4 contains a consequential amendment to Section 19, which is in relation to Clause 3. But this is where there's an appeal against an enforcement notice. So if we look at the law and go to Section 18, Madam Speaker, Section 18 speaks to, in the middle of the section itself, in respect of any development have not been complied with, then the director may, within 3 years of such development being carried out, or in the case of non-compliance with a condition, within 3 years after the date of alleged failure to comply with it. Madam Speaker, that has been the case forever and ever. And in simple terms, what it means is that within a 3-year period of construction, that anything that is not compliant, or if a person has built without planning permission, the department can act by way of enforcement on the illegal structure. So the fact that the law was changed some time ago, allowing planning permission to be still legal up to 5 years before it lapses, means that these two sections need to be put in line with the 5-year period. Otherwise, they contradict each other. And if we go to section 19, in 19D, and it speaks to the breach of planning control alleged by the enforcement notice occurred on a date earlier than 3 years before the date on which the notice was served. That too, Madam Speaker, needs to be changed to 5 years. So those three times, twice in section 18 and once in section 19, which refers to 3 years, will be changed to 5 years to mate with and be compatible with the amendment to the law that's already in force, which says that planning permission does not lapse until 5 years after it is granted. Madam Speaker, Clause 5 amends Section 29A to empower the Central Planning Authority and the Development Control Board in Cayman Brac and Little Cayman to issue maintenance of land notices in respect of dilapidated fences with walls and derelict equipment in addition to dilapidated buildings. Madam Speaker, this is a sore topic in the minds of many, because it is felt now that people are really allowed to do as they please, and there is no teeth in the law by way of people who own properties or dilapidated buildings or fences or the place growing up and really looking bad in a neighborhood that is otherwise looked at as, may I just simply term it, as a decent neighborhood. So what this section will do, it will allow the CPA to deal with fines. And I just want to read what is being replaced. It says the principal law is amended in section 29A by repealing subsection 1, which obtains now, and substituting the following subsection. And that reads as follows. If it appears to the authority that the amenity of an area is adversely affected or seriously injured by reason of the ruinous, dilapidated, or other condition of any building, structure, fence, or wall, or by the condition of land due to the deposit of refuse, spoil, derelict vehicles or equipment, or the occupation of land or a road for purposes of the repair of vehicles of equipment, and that rings through a whole, or should I say many areas. It may serve a notice under this section on the owner or occupier of the land or building, or B, the person responsible for causing the condition of the land or building. Madam Speaker, the next section is whereby Clause 6 is seeking to repeal Part 4 of the principal law. Part 4 of the law, Madam Speaker, comprises of provisions dealing with compensation for the refusal or conditional grant of planning permission. These provisions have existed for many years, but have never been utilized. Moreover, the implementation of Part 4 could have a significant negative effect or impact on the operation of the CPA and could result in a significant financial burden on the government. And in addition, Section 48 of the law already contains provisions for an applicant to appeal against decisions of the authority, which can lead to costs being awarded by the appeals tribunal. Madam Speaker, in simple terms, and I think I'll use a specific example, which is what brought this whole thing to light, which was not very long ago. There is a parcel of land which is zoned medium density residential. And there was an application for the construction of a church on the property. The property is on the main road, and there were, I think, I don't want to be misquoted, but I believe there was difficulty with the parking requirements besides the seeking the variance for it to be used for institutional purposes rather than medium density residential. And there were objections from adjacent landowners and people who live in that area. Their biggest objection, not about a church, but about the number of the congregation, where they would park, and they considered it a dangerous situation. So based on the objections, the CPA refused the application. And the next thing was a letter from the applicant through their legal counsel saying, well, okay, if you can't grant me permission to build a church, then you either buy the land from us or give us money because of whatever all of those legal terms would be. As I said, Section 48 allows an appeal against any decision made by the CPA already. But I don't know when this law was made years and years ago, this section, when this was done. I can't, no one who has been dealing with this, even those who have been there for quite some time, can't explain to me what the thought process was behind this, because I just, even though I don't understand why it was there, I guess it was never used because people realized that the Central Planning Authority, if they make an error in law, which is a rare occasion, except it's the other way around to benefit the applicant, then there is other redress through Section 48. But to leave this section in, Madam Speaker, and for this section to literally say that someone could seek, if the CPA doesn't grant permission, someone could seek some type of compensation, it really exposes the government to the kind of liability that not only is it not reasonable and not fair, but it shouldn't be the case. Besides the risk of any payouts, Madam Chair, all this does is create avenues or an avenue for more legal wrangling and tangling, which I consider to be not only unnecessary but costly. So hence is why we are proposing to totally repeal that section, Part 4. Madam Speaker, the last amendment is seeking to amend Section 40 by, I'm just looking for it in the, yes. By deleting the full stop appearing at the end of paragraph E, which is after the word male in the actual law itself, and substituting a semicolon, and by inserting below paragraph E the following words: but notice required to be served on any person pursuant to section 15 subsection 4 shall be served by sending it in a prepaid registered letter addressed to that person at the person's address as stated in the land register. Madam Speaker, this is not a perfect situation, but let me tell you what is happening now. Using other means to serve the notice. Other more modern means such as electronic means. We are continually hearing people say, I did not get it, I did not get it, I did not get it. And there really is no easy way to prove whether they did or didn't, even when somebody else's computer says it was read or whatever like that. So legal opinion has been that you cannot legally say the person received it if there is no real evidence. That is what we understand. And if we go through that whole process, sometimes, not often, but sometimes there are hundreds of notices being sent. Oftentimes there are dozens and dozens of notices that have to be sent. And Madam Speaker, you get one or two saying we haven't gotten it. It just stops the whole process. Then you're battling, how do we prove that these people got it, and natural justice and all of those kinds of things. So what the department, that is the planning department, has been practicing for the developer who may have to send out notices is, here is your list of who has to be notified. You bring us the receipts for your registered letters that you put in the mail, and those receipts are proof to us that you sent them. And that is what this amendment seeks to do, which is the requirement for those who have to send out notices to do it in this manner. Madam Speaker, again, some people will say that this is a pain and it shouldn't happen, but at least we can't figure any other way. And we have batted it back and forth, sought legal advice, and can't find any other way. This way, Madam Speaker, if this rule is followed, you do it one time. How it is happening now is it's a bit chaotic, and it also frustrates developers when it comes to sending out notices. They say they sent them out electronically, and the people say they didn't get them, and the developer says, of course you got them, and they say, no, I didn't get them, and it goes on and on and on and on. So, Madam Speaker, those are the, what I term, simple amendments that are being proposed for the Development and Planning Law 2015 revision. I hope that my explanations have been clear enough that members understand what is being proposed, and I do trust that members will find it in themselves to support the motion, and or the bill, forgive me, the bill so that I don't have to talk much longer. Thank you.
Does any other member wish to speak? Does any other member wish to speak or recognize the first elected member from Bontown?
Thank you, Madam Speaker. Just a couple of observations and some guidance from the Minister. Subsection 5. This goes back to the history. Yes. Clause 5. As you may remember, in the distant past, there were supposed to be a number of enforcements in a certain subdivision in the Savannah area to remove some vehicles. There were many of these sent out. And what I'm wondering is after, and this also would go over to the clause 7 of the amending, when what enforcement takes place in the services of notices without corrective action, as had evidently transpired at that time. And the other question I had, I see there's a church that has opened into the old tall tree area. Just wondering where the congregation parks there, because where I see in that specific area, maybe they have another place where they can do it. It's probably 5 or 6 parking spots. I just wonder how that's being looked at. Just those comments, Madam Speaker.
Does any other member wish to speak? Does any other member, the member from East End?
Madam Speaker, there are a couple of things that I would like the Minister to clarify. The first one being that he said in his presentation that this amendment would now require the building of walls, regardless of the height, would require planning permission. And, well, I don't know, because, okay, but you're adding it on to, it's being added on, Madam Speaker, on to E under 13. 13.3, 13, Madam, I beg your pardon, 13.3 E. 13 says, 3 says, in this law, development means the carrying out of building, engineering, or other operations in, on, over, or under any land, the making of any material change in the use of any building or other land, or the subdivision of any land, except that the following types of development shall not require planning permission, but shall be subject to all other provisions of the law. Shall, the operative thing is shall not require planning permission. So I don't know. And E then says the erection of or construction of gates, fences, walls, or other means of enclosure not being within any setback adjacent to the sea, or roads now added. Yeah. But you're saying within. You're saying that there was a mistake with, there should be within. I don't know. I think somebody need to clarify it. Because, Madam Speaker, the Minister was saying that, the Minister was saying that the Attorney General might be able to change it to within. I don't know. Huh? Well, you can't listen to both of us and expect to succeed. We often have opposing views, but respect for those. Madam Speaker, the other one that I is the all right, okay. Quick as that, I have vindicated myself. Okay. Madam Speaker, the other one is 29E, where we're changing that. I think the only thing we're putting in there is building and structures, eh? But Madam Speaker, my biggest concern here is we continue to put these provisions in one law or the other to ensure these things are not done by the public. But every time we call planning, or we call the police, or we call the NRA, or we call the DEH about, and you call different ones for different reasons. DEH, it's a health hazard, we would consider it, and the NRA, it's a hazard on the road, and then planning, it's a planning matter, land use matter. With all these cars all over these pieces of properties in Cayman. And every department sends the fool a little further. And here we are today renewing the provision to send the fool a little further. Well, my opinion is just as good as anybody's else. But Madam Speaker, it's really, I don't know what a minister could do. I'm just trying to bring it to our attention that it don't make sense, it appears, to put these provisions in law, because nobody utilizes them. The only reason, Madam Speaker, Clyde William building got cleaned up was because it was for dark, and the company was embarrassed by what was going on up there, having leased it to someone. That's the only reason it got cleaned up. Because the authorities of the government, or whichever, the departments or whatever, don't do anything. There's a lady in Tropical Gardens. From time Christ on Rivera Beach, she been trying to get them off that road up there, Tropical Gardens. Well, it might be between the times that I went there that they move them. No, the one by Jose was the one down by the dump. Same said guy. Well, we need deport him to some place or something. If he moving that many places, tell him don't come east there. Madam Speaker, it really unsightly. They're in the yard. It's worse. Madam Speaker, it really unsightly. It's something that we're not used to, and more so since Ivan. Right there by Napa. There's just under 1 billion cars there, I would estimate. I don't know what's the use of us making laws if we're not going to enforce them and assist the government employees, the civil service, empower them to utilize the laws. When I was minister, they were parking them on the side road, the little slivers of land that we were getting. And I made them put a little paper on the windscreen. Have them move by the 30th of this month. And on the 29th, we engaged Avery Towing Company. We were calling them dump crusher. That's the way to do it. I don't know. NRA does what they have to do. Honestly, you sit down with that. I called about one vehicle in on High Rock Road now. 9 months, Madam Speaker. Say they don't know who it's for. Look at the VIN number since the license plate's gone. That a third sticker, Mr. Premier. It washed off. The rest of them been there so long. That's a fact. Anyway, I just bring that to the attention of the minister. The other one, Madam Speaker, is the provisions about service of notice to the registered with registered letter addressed to the person at the person's address as stated in the land registry. And I know the minister is trying to find some easy way of doing this, legitimate way that you can say that it did happen. But I hasten to tell him that ain't the answer, and I don't know where you're going to find the answer. Because in many instances, Madam Speaker, the people address on the register has long been outdated. Well, Madam Speaker, I would love for the situation to be as he is just elucidated. But here's what happened, especially when they are in can make claims. That time runs out, and then when they find out about it, they then say they didn't do it, and the court, it does, yeah, but it's claims on their properties. Madam Speaker, I've known of a particular case that cost millions of dollars to defend with the same thing. And I'm not saying that this cannot be tried. I'm just saying I don't know if it's the panacea. And I don't know how to do it, Madam Speaker. I'm just saying it's unfortunate that that's the situation. And I hope what the minister is saying is that it's their responsibility, that's the end of it. I hope that's, and if that's what the legal department tell you that is possible. And the last thing, Madam Speaker, is with these walls on the road. I spoke to the minister, but it's worth repeating here, I believe. There is no easy answer to building these walls on the roads. One size doesn't fit all, and you cannot make provisions for every eventuality. And I say that to say that we have lost so many lives with chain link fence. Now, we could say that we need to ban chain link fence, but what else do you put up there? We have lost lives with concrete walls. We have lost lives with with picket fence because the 2x4 come through the vehicle. I've seen that. CUC poles and the likes. But of course, every time one of these things happen, it becomes an issue. It becomes a sensitive issue, and you get representation on these matters. But no human being can make provisions for everything. And we can't be there driving, holding people's hands anyway. The only thing we can do is remind people of their own responsibility for their own safety. But accidents do happen. But I don't know what Dan says, Madam Speaker. It's a challenge. Yeah. Anyway, Madam Speaker, I don't have too much problems with it. I see where he's removing that section 4, and he did say that one could claim compensation from the tribunal under 48, but Madam Speaker, I should also point out to him that under 48 you can go to Grand Court too, if you agree with the tribunal. So I shall leave that to the luminaries to see if it works that way.
Does any other member wish to speak? Does any other member wish to speak? Final call. Does any other member wish to speak? Honorable Minister of Planning.
Thank you, Madam Speaker. Madam Speaker, first of all, let me say thanks to those who have spoken, and my good friend, the Honorable Deputy Speaker, the first elected member for Bordentown. I don't know the answers to the specific situations you speak about now, sir, but I would like you to just remind me, and I will find out and let you know. I've had somebody ask me about that already, and I've seen the sign. That's one of them. That's a church thing. But I don't know exactly what the situation is, what planning permission is, or where parking is for it. So I'll determine that and let you know. The member for East End, I think besides the joke, or the jokes and the banter, I believe now that maybe that word should not be within, but should be as is and I should never doubt the wisdom of the drafters. I just thought this was a simple error. The member makes, so I think we'll also confirm that to make sure that should be with. The member makes a very valid point about the delays in getting people to remove vehicles or do the right thing. But if we look, and it's not, you simply cannot not allow due process. That's the problem. Yeah, well, this, yes, no, but, yeah, but there have been changes made to that so that there is a finite time period for that. But you cannot not allow the court process. We tried that. We can't not allow that. So what this will do is when you serve the notice, if you continue to read on in the substantive legislation, Madam Chair, it tells you the fines, whether it's commercial or otherwise, of $25,000 a day. And if it's residential, it's $5,000 a day. So the point where you are now is once you take it to court, once you take it to court, I believe that the fact that those fines, on conviction, those fines will be from the day the notice was served. people are going to be paying a little bit more attention. Per day. Yeah. Madam Speaker, I understand exactly what the member is saying. Unfortunately, there is no answer to do what he and other members, including me, have in our minds and would like to do to make sure that these people pay attention. It's just a legal process that you simply cannot avoid. You have to give them the same rights by giving them time to fix to remedy whatever the situation is. Then if they get a 28-day period or a 30-day period and they don't fix it, it is then up to the department to follow through by way of going to court. And Madam Speaker, I think that it is fair comment to say that the various agencies, and this is, I want to say this carefully, but I think it is fair comment to say that the various agencies have not made it a point of duty to follow up over the years on these particular cases. And it is entirely up to us who make the laws to impress on the various agencies. And I certainly have been doing so with mine, and I will do so more. But there is also at times the Department of Environmental Health who are involved in the moving process also. And I think that it is more a matter of the agencies doing what they should be doing. And I'll leave it at that for the time being. Like I said, Madam Speaker, these amendments are not very, very controversial amendments. It's an ongoing process for us in looking at the development and planning law to seeing what improvements can be made. And sometime later on in this meeting, there will also be the two government motions which I will have to bring on the amendments to the regulations and also the building code regulations, at which point in time we will discuss further changes which are being proposed with a view to streamlining the process even more than has been done. I want to thank all members who have spoken, and for those who haven't spoken, I say an anticipated thank you for their tacit support. Thank you, Madam Speaker.
The question is that a bill shortly entitled the Development and Planning Amendment Bill 2016 be given a second reading. All those in favor, please say aye.
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 Against, no. Believe the ayes have it. The Development and Planning Amendment Bill 2016 has been given a second reading. I recognize the Honorable Premier.
Thank you, Madam Speaker. Madam Speaker, I wish again to record my thanks to all honorable members for their cooperation today and record the great strides we have made in completing the business for this meeting. I would just like, Madam Speaker, to indicate to members so they have due notice that obviously tomorrow is private members' motion day. On Friday, tomorrow I hope to have either a full meeting or by round robin of the business committee, and to put on the elections bill for consideration by the House on Friday, because the Honorable Deputy Governor will be away next week and he has carriage of that bill. So just want to indicate that to members. And Madam Speaker, with that, I move the adjournment of this Honorable House until 10 a.m. tomorrow morning.
The question is that this Honorable House be adjourned until 10 a.m. tomorrow morning. All those in favor, please say aye. Against, no. The ayes have it. The House now stands adjourned until 10 a.m. tomorrow morning.